Welcome back to our weekly series, Frequently Asked Fridays, where we answer your questions about intellectual property law. My name is Rick Martin with Martin IP Law Group, and today we're going to talk about copyrights. The last 2 weeks we've talked about patents and trademarks, so we're going to switch gears and talk about copyright here. The question this week is similar to the question from last week. Do I need to register my copyright? And again, the answer, much like last week with regard to trademarks, is no, but there are some distinct advantages to registering. So let's talk about copyrights in general. What is a copyright? What does a copyright protect? Copyright protects the expression of an idea in a creative work. Typically applies to music, to art, sculptures, paintings, movies. It applies to books. Any creative work that you can think of, copyright protection applies. And copyright protection, at least under U.S. law, applies automatically upon creation of the work. So when you finish your painting, when you finish your song, or when you publish that work of art or that song, copyright protection is effective immediately. So you do not need to register that with the Copyright Office in order to have copyright protection. However, there are two primary reasons to register your copyright and to register it sooner rather than later. The first reason being that the law says that as a copyright owner, you cannot file suit against someone for infringement of your copyright until and unless you have registered or at least attempted to register your copyright with the U.S. Copyright Office. Typically, it's several months is the process in order to get a copyright registered. So if you find out, let's say today, that somebody is infringing your copyright, you can get it registered and can sue them. But if you pursue that through the normal channels, you're probably going to have to wait 6-8 months potentially before your copyright is registered or you get a response back from the Copyright Office that would then allow you to bring suit. There is a way around that, and typically if your copyright is in being infringed or is in imminent danger of infringement, you can request that that copyright application be expedited. And for the mere additional $800 in filing fees, the Copyright Office will bump you to the front of the list, and you can typically get that copyright registered usually within a week to 10 days as their turnaround time on that if it's expedited. Again, it's going to cost you an extra $800, but if somebody is out there actively infringing your work, it's worth the money to do that and spend that so that you can take action right away and not have to wait 8 or 9 months in order to pursue somebody who's infringing your work. Another good reason to register your copyright before infringement occurs is something called statutory damages. Statutory damages are just what they sound like. They are damages that are prescribed specifically by statute, and the amounts determined there by the statute are typically between $750 and $30,000 per act of infringement. The court can also, if they find that the infringement was willful, increase that to up to $150,000 per infringement. So there's some significant amount of damages there, and the nice thing about statutory damages is you don't have to prove that you were actually damaged by the infringement. Typically, you are going to have to show either that you somehow lost money as a result of the infringing acts, or that they somehow, the infringing party somehow improperly made money off of the infringing act. Sometimes that's not easy to do, and unless statutory damages are available to you, you're going to have to show damages in one of those two ways. Statutory damages gives you a much easier, cleaner, and more efficient way to show damages. And again, sometimes you may not be able to show actual damages. Statutory damages are going to provide you with relief even if you weren't actually financially harmed by the infringing activity. However, with regard to statutory damages are only available if you registered the mark before the infringing activity took place. So if you wait until the infringement happens before you bring action against the infringing party, statutory damages are off the table. You cannot get those, and you're going to have to prove damages by one of the two other means that we talked about. So very important there to register your mark early in order to take advantage of statutory damages. And again, important to register it so that you can bring suit if you need to. That pretty well covers this topic for this week. Thanks again for tuning in to Frequently Asked Fridays. And if you have any questions about copyright, patents, trademarks, trade secrets, or any other intellectual property matters, feel free to reach out to us, and we'll be happy to talk to you. Thanks. Have a great weekend.